Hey, if you don't change your ways, you know you're going to end up spending the rest of your life in prison or jail. You understand? All right, the court is calling 2025 CR 013959-02, State versus Gilbert Quay. Can I have parties announced for the record?
Brandon Brader, State.
And Jonathan Alvarado for the defense.
And are you Mr. Quay?
Yes, ma'am.
All right, off the record for a moment. Deputy Laura, can you have them move to the other end? All right, we're back on the record. Counsel, have you received all discovery that you reviewed with your client?
Yes, Judge.
Court will find that the state is in compliance with discovery. Are there any applications?
Or not, Judge.
All right, Mr. Quay, did you review the true bill of indictment with your attorney? Did you understand it?
Okay.
Counsel, do you waive the reading of the indictment?
I do, Judge.
State, are you proceeding on the indictment as presented?
Judge be waiving the punishment enhancements, but otherwise proceeding as filed.
Any objections to the waivers?
No objection, Judge. Thank you.
You're welcome. Mr. Quay, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with deadly conduct discharge of a firearm as a third-degree felony. Sorry, just a moment. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea with the state, the court does not have to follow your plea. If for any reason that the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand? You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering this plea, you're giving up those rights. Did you intend to give up those rights and enter into a plea in this case? Counsel, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Quayar, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
If you're not a U.S. citizen, by entering this plea, you will be deported, denied naturalization, and re-entry. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 2 years in the prison. This will run concurrent with 2019 CR 5300. Did you understand that to be your plea? Defense?
Yes, Judge.
State?
Yes, Judge.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
By signing that, you're waiving your right to appeal. The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
There have not, Judge.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest? I'm sorry,
No contest.
state any evidence?
Judge, you have to say exhibit number 1 and all of that.
No objections.
All right, state, you may be excused. Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand? Court will find that defendant has knowingly and voluntarily waived and consented to stipulations of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Judge.
Anything you wish to say on behalf of your client?
Judge, just that he's ready to move on with his life. He is on parole for the case that's being run concurrent. And so he's going to go back to TDC and serve his time on both this case and that case, which asks you follow the plea bargain.
All right, the court is finding you guilty. The court will sentence you to 2 years in the prison. Give you credit for any time served. This is to run concurrent with 2019 CR 5300, and there's to be no residing in households with children. Did you review the document titled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand? All right, so we can go off the record. Hey, if you don't change your ways, you know you're gonna end up spending the rest of your life in prison or jail. You understand? All right, do better, okay? All right, good luck to you.
Thank you, Judge.
And Charles, they say you have someone else on the.
I have several more, but the next one is Urabas, Maricela Urabas.
All right, and have you ready to proceed on that?
We are going, yeah, we're going to rest for, the state's asking for a reset, so we're ready to proceed.
All right, could you have your client come up?
Yes, ma'am.
Mr. Paramio? Doris? Yeah.
Hi. All right, state. Oh. All right, then it's you, Mr. Bond. No, it's family violence. All right, what is happening on this case with discovery? Or what
There
do they
is
need to
a-
reset?
The state, we reset it last time for the state to talk to a witness. I've been informed they spoke to the witness, but not enough to make a decision. So they'd like a brief amount of time to finish that discussion
All right, 3 weeks.
at the most. I was thinking 2 weeks.
All right, Ms. Ferguson, I need a 2-week reset on your ribis.
I'm sorry, Judge.
A 2-week reset.
Yeah, I got to file the motion on the state talking to her right now. And we're going to be filing a motion, Judge, to change her no contact to no harmful injuries. The state is with the complainant right now.
Okay,
March 12th.
Okay, March 12th.
yes.
Okay,
All right, once you sign the reset form, you'll be excused. Thank you.
I'll bring it to you right now.
And Norma, that's for the state to, they're speaking with the complainant, but also for them to tender an offer.
That's fine. I took care of it. Thank you.
Yes, no problem. Sure. I'm sure going outside a lot. Let's see what's going on. On who? Okay. All right, Melissa Paez. Norma, on this case, it's set for sentencing. State, this is Melissa Paez. It's set for sentencing, but defense counsel is out of county on another matter. So is everyone okay? It's an opposed offer. I don't know. Did you all have witnesses?
If we're not opposed to it, if you want to accept it.
Okay. All right. So we won't be able to do it on Friday because I have a mental health docket.
Okay,
So if you can speak with Ms. Ferguson and you all come up with a date. So we're just trying to get a date for your attorney to be here, okay? So if you'll confer with her and then let me know what date y'all have decided on.
yes, ma'am. All right, thank you, Judge.
Thank you.
Thank you. I just make sure what the calendar looks like for next week. Sure. Thank you.
All right, anyone else ready?
Yes, it's on the second page.
Jamison Franklin.
The courtroom is a stage where lives are traded in legalese. At its center stands Gilbert Quay, 19 years old, his youth a stark contrast to the weight pressing down upon him. This is his second setting, and already the machinery of a plea bargain has been oiled and set in motion. His attorney announces the prearranged terms, fees waived for a GPS monitor, permission to work if he can prove his job. The state has signed off. The deal is done before the judge even asks for his name. Miss Ferguson, the judge, notes his age with a flicker of mercy. 45 days to consider a plea, because young people need more time. But time is an illusion here. The clock is already ticking toward April 13th, toward a surrender that feels inevitable. Gilbert Quay is charged with deadly conduct, discharging a firearm, a third-degree felony. The range of punishment stretches from 2 to 10 years, but the bargain has already been struck. 2 years served concurrently with a prior case. The hearing becomes a ritual of waivers, the right to a jury, the right to confront witnesses, the right to remain silent. One by one, Gilbert signs them away. The state presents its evidence, statements, police reports, no live testimony. The judge reviews the exhibits in silence, and then the verdict falls. Guilty. 2 years in prison, a concurrent sentence. And then the final warning, no residing in households with children. The judge leans in, her voice dropping from formality to something almost human. If you don't change your ways, you're going to end up spending the rest of your life in prison. A plea, perhaps, wrapped in a threat. Gilbert Quay, at 19, walks out with his freedom suspended, his future reduced to a bargain he may not yet understand. In the end, justice did not demand a trial, it demanded only his signature.